And we are live. Hello, everyone. Welcome to the Alien Spaceship stream. You could be watching from anywhere around the country or the world, and I really appreciate every single one of you coming to you from the Spaceship Studios from a galaxy far, far away. And now we're going to be switching over to the other part. Let's go here. Alright. Hello, it's I, Alien Spaceship. Hope everybody's having a good day, good evening, good afternoon, wherever you are. And we are doing our late night, not necessarily late night, but our night stream of reacting to things and looking at, probably playing a game for a little bit too. Okay. Now, something going to be doing, I'm going to be in the background, but I'm going to play something for y'all to look at while I'm in the background, probably. Okay. Hey, let's go here. And there's two of me. Alright, this way. Now we're going to be going here and watch some more grounds. Okay, here we go.
I just checked this morning to see if there's anything new. Nothing has been received at my office. And I should say the clerical that was assisting me went to the mailroom to double check. So not only has it not made its way to the DA's office, it hasn't even made its way over to the mailroom.
I can email the jail administrator to find out if there's anything in transit, if there's no objection from the parties, from the state.
No objection?
From you, sir?
No objection. I definitely want those documents received if they obtain important information.
You said you forwarded them to a staff member on Saturday?
Yes.
Do you know if that was morning, afternoon, or some other time?
Maybe afternoon.
And those are two ICF forms?
Yep, one addressed to you directly and one addressed to the district attorney's office.
I'm sending that. I will send it with high importance and we'll see what response I get. But I don't have anything. If you want to generally tell me the topic, we can cover it verbally.
The topic is pertaining to exculpatory evidence. Some things were learned, and once they came to my attention, I felt the need to immediately address the court about this information.
All right, what information? Make an offer of proof for me, sir.
The expert witness for the prosecution in regards to, I believe it was inspecting the vehicle, Officer Ryan Schultz. Question was asked of, did he know if there were any recalls on that vehicle? And I believe that a Brady claim should be visited because there were in fact recalls on that vehicle. In fact, there were recalls on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where Ford company were sued because of this, and those vehicles, models from the year 2008 through 2010, were recalled. And that is very important information in regards to the vehicle in question being a Ford Escape 2010. This information is very easily obtained just by pulling it up, and you will see a class action lawsuit. Obviously, if it's a class action lawsuit, then it's pretty easy to.
So what's your request, sir?
My request is to find out if Officer Schultz knew, to find out if the prosecution knew that there was a recall on those vehicles. And in light of the fact that these vehicles were recalled because of this malfunctioning throttle body for I believe it's counts 1 through 73 to be dismissed.
All right, what's the response from the state defendant?
Thank you, Your Honor. As Trooper Schultz testified during his examination, consistent with our research, there are no active recalls listed for the Ford Escape. As Trooper Inspector Schultz noted during his testimony, that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old and has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report. There was no recall in the throttle body. NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the electronic throttle body failures would have resulted in engine stall or surge while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here. Further, Inspector Schultz would testify that that does not prevent the brake from working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car. Further, if this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the indicator lights. None of them were lit. Further, if there was this, he would have observed material buildup on the commutator. There was no such buildup observed. There were no problems with the throttle, electronic throttle body. That was part of his report. Therefore, this is, although there may have been some cars who had this problem, the car that the defendant was driving on this day did not have that problem. That was testified during the vehicle inspection. The defendant had the opportunity to cross-examine Inspector Schultz with regard to that. And again, in running the defendant's mom's VIN number through NHTSA, National Highway Traffic and Safety Administration, there are, for this particular VIN number, for this car that the defendant was driving, 0 unrepaired recalls. So it's a moot issue.
I don't believe it's a moot issue, and I actually have, the report should be in the mailroom as we speak. I had everything sent over priority mail, the actual information about the class action lawsuit, the actual information about the recalls for those models. Like I said, 2008 through 2010, Now, in all fairness, Your Honor, that's why I was asking for a Brady claim on this. Seeing as how when vehicles are purchased from the manufacturer, they're still sold as is. There would be no way to know that there's anything malfunctioning with the vehicle until it actually happens. And seeing as a class action lawsuit, no one would sue the Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit if these vehicles were not malfunctioning. And I believe with that, like I said, the information is easily obtainable. I should have the information in the mailroom right now, that you can readily view this information about the class action lawsuit, about the recall on. It wasn't just the 2010 model in question, it was 2008 through 2010. The information about the malfunctioning pertains strictly to the throttle body.
Let me address your claim, sir. So, not trying to cut you off, I don't need the specifics about a class action, because as it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even indicate it was readily known and something you were able to find out. I'd further note that you had a full and fair opportunity to cross-examine the inspector regarding his mechanical inspection. It's not new information. And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. Because again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls, and more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it. I am aware that the ICF, I did receive an email, it's one page with what you said. I have to turn my head, I gotta figure out how to flip it. So give me a second.
Okay. And just for the record, Your Honor.
Hold on, let me finish my record, okay? So I'm gonna turn, because it's the only way I can read it. It says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled no later than Wednesday. I just learned of some information that is extremely vital. I understand the information that you're providing me, but again, you had a full and fair opportunity to cross-examine this witness. This information was apparently well known. I'd also note the vehicle's registered to your mother, and from my understanding of recalls, I think what is common knowledge is that a registered owner would receive information regarding the recalls and what to do, and presumably she would have provided that information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof that even she received that information and did nothing with it, or whether anyone else who operated that did anything with it or not. The bottom line is there is absolutely no Brady violation by the state. This is not the type of information they would have been required to turn over. And from my understanding and review of Exhibit 83, what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and found that as to this particular vehicle, there were no issues with that would have impacted the mechanical function during the incident in question. I'll accept the state's offer of proof as to what would have been the issues based upon the information provided. And again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request to dismiss the case, and I'll deny the request to recall this witness.
Your
Hold
Honor.
on. Hold on. Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
The Inspector Schultz's mechanical inspection report was provided to the defense on April 29th, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him, and it was asking questions directly related to information contained in that report.
All right. Go ahead, Mr. Brooks.
When you spoke to the owner of the vehicle, that's who gave me the information.
Right, and Nan says it seems he did. I've heard the expression blind rage, but never thought of it really. Thought of it literally. Yeah, definitely the blind rage is something that he seems to think of, that he actually acted on, because we've heard these types of idioms and sayings before, but he really took the cake with it. He acts like a toddler having a tantrum, but it's an adult form, and it can be very dangerous. And he lacks, as I said, impulse control, empathy, and he just, without a thought, he just does this action for no apparent reason. And he would blame that the vehicle had a malfunction in it. Now, the vehicle he had did have some of that brand. That model had an alleged defect in it, but I think that is an excuse by him, and he didn't have any attorney, where he chose not to have an attorney. That was another red flag about him, and he was just going off and saying doing these things in court, and he just showed guilty. He was guilty by the way he acted. So yeah, the crime, it was blind rage. He just wanted to go destroy something, and he just went and did his thing, and murdered people and ruined lives and injured others. Then he is actually the one that's having a problem, not the other people in his own mind. So yeah, he just if a kid on a playground gets in a fight or something, it's not good. But when you have an adult acting like that, it could seriously hurt somebody, as you could see. So yeah, it's certainly an example of the phrase blind rage, definitely, but it's not something he was going to get away with. Yes, violence is his go-to. That is very true. He also did something with an underage. He went with one of the people when they're underaged, and he gets angry, and he was saying that she said she was 18, but that's not really an excuse. He could say there. So he also did that, and yes, he was abusive to his young girlfriend. That's true. He has a history. This guy has a record of doing things. It wasn't just a one-hit wonder. He consistently had that behavior, and his mother claimed that he was bipolar from when he was little. So he always had something not quite right with him. Right. The car, his mom's car, was a hope, but wasn't a reason why he didn't stop. Correct, Nan. Correct. A defect like that, which it was not a defect. He went and sped through a crowd. So there's barricades, and he's going somewhere, and he's turning, and he goes through, then turns this other way, and goes straight and hits everybody. So that's certainly the car malfunctioning didn't do it. There's also an emergency brake you could pull in a vehicle where I would think it would help stop the car, but the SUV, but yeah, that's certainly not the same situation. And Fifi said, I feel that you're picking on him nightly. Now, good to see you, Fifi. Welcome to the stream. And Nan says the car, his mom's car, was a hopeful reason why he didn't stop. Right, so that should explain the answer. Now, Fifi, I am playing this because I was doing something with the cat and I couldn't get here right away, and we have some other people that didn't see the reactions I've done to it yet. But yeah, he certainly, I do, not his biggest fan. It's not maybe the most favorite person. I like to review this trial, but I just had to get something done, and then it was going to get back to another thing. But I'm seeing one of my people are interested in this trial, so that is what we are looking at the moment. So, but I'm not a big fan of him, I will say. But of course, there's other trials to look at as well. All right, and Nan says, or he could have taken the keys out of his car. Yeah, he could have taken the keys out of his car. That's another thing he could have done, and that surely should have stopped it right there. See, there's different holes in his narrative to poke into. I think that is something avoidable that he could have done. Hello, Denisha. Good evening. Welcome to the stream. Hope you're having a good evening. Okay. Let's continue.
My mother gave me the information of this. I had no knowledge until she told me. And that's how I came into the information. And she was the one that said, I'm going to send you all the information that you need so you can present it to the court. So
I understand that, sir, but your request is not timely. So you have had this information for quite some time, either through counsel.
I did not have it for quite some time.
Let me make my record. Either through counsel.
It was just told to me.
That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case. The fact that you have now learned this, it's a little bit too late. And I understand that may seem fair to you, but even when I consider the information that you're providing to me, it's speculative on your part as to whether there's any impact on this particular vehicle because of the inspection that was done. And you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you cross-examined this witness.
It was not readily available for me to expect at the time. I don't have access to the internet. So how would I be able to?
Mr. Brooks, you're telling me your mother had that information.
No,
so,
I'm
and
telling you, she just told me this information. I have the phone calls to prove it.
I understand that. I'm denying the request, sir.
And I would like a.
So that's my decision.
I object to that, Your Honor.
Hello, Lori. Good evening. Welcome to the stream. Thank you for listening. Okay.
I understand. I've made my decision. I expect that you respect the decision, at least as we're not going to debate it further.
Yes.
I now have the ICF, the one for the state to be provided to the state. Madam Clerk, I just gave that to you. All right, so Mr. Brooks, in light of that.
I respectfully object, Your Honor, and request the legal reconsideration of your ruling, Your Honor.
It's denied. The request for reconsideration is denied. There's no legal basis for me to do that at this point.
I respectfully reject that ruling and take exception to that ruling, Your Honor.
All right, Mr. Brooks, we need to keep going.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
I provided an oral ruling today. The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue?
Your request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter?
I wouldn't be the one you would make that request to, sir. So I can't answer that.
For the record, may I move
yes
to
or
stay
no.
these proceedings until the instant matter is adjudicated by a court of competent jurisdiction?
That request is denied.
Based on what law or fact, Your Honor?
The request is denied.
Based on what law or fact, Your Honor?
Any other requests, sir? I'd like to move on.
Based on what law?
There's no legal basis that you've stated for me to do that, sir.
It has been, Your Honor.
The request is denied. The request is not a proper motion. There's no legal support for the motion. There's no factual support for the motion, so it's denied.
For the record, it appears that this court is acting in contempt of the law, Your Honor. Can you show me how or where this court is following the law of respecting this matter?
That's a very vague statement, sir. There's no legal relief that you're claiming. There's no motion before the court based in law or fact. So this court cannot address that last statement of yours.
Your Honor, with all due respect, I would like a motion for finding a fact.
Denied.
Under what law and fact?
I made an oral ruling, sir. There's no requirement I do so in writing.
So you're denying a legal, you're denying a motion for finding a fact?
I am.
So how do I know what you're doing is legal, Your Honor?
All right, Mr. Brooks, we're going to move forward. At this time, I want to...
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Mr. Brooks, we're moving forward. So your
Doesn't
request
seem
is
like
denied.
it doesn't seem
Mr.
like
Brooks,
you're-
I need to give you some
It
advisements,
doesn't
and I'd
seem
ask
like
that you
you're. I
stop
don't need
interrupting
your
me.
advice.
No, I have to
need
give you advisements, sir, regarding your right to testify.
I need to do your job without prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's failing to respect the court's oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right to testify.
You don't need
Do you
to
have
go
a
through-
witness
you
to
don't
call,
need to go
sir?
through anything with me on record. You
Actually,
need
I
to,
do so,
actually,
sir.
you
That is
don't.
required by law.
Actually, you don't. You need to do your job as a public servant.
Mr. Brooks,
and honor the oath that you
I
took,
need to go
Your
through
Honor.
these advisements, and if you're going to keep interrupting me, you will forfeit your right to be present, and you
So
will
you're
be
holding me in
removed
contempt
to the next courtroom so that I can properly go through these advisements without being interrupted.
And I still don't have to answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt yet again.
Mr. Brooks, I've not held you in contempt. I've found that you have forfeited your right to be present by your conduct, which is one of the options available to this court under Illinois versus Allen, under State versus Vaughn. It's also referenced in State versus Anthony. So I am going to keep going, sir, despite your protestations.
Your Honor, with all
I need
due
you
respect, in
to
Illinois
not
versus
interrupt
Allen,
me.
in
This is
Illinois
another
versus-
interruption.
In Illinois versus Allen.
Mr. Brooks,
do
I'm
they
not
say-
going to have a debate with you on
I'm
the
not
meaning
trying to
of
have a
Illinois
debate.
versus
I'm
Allen.
not trying to have a debate.
You are
I'm really
advised
trying
that
to
it
understand
continued.
Illinois versus Allen.
Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying that
I've said that multiple times. I've given you multiple opportunities to stop interrupting me.
You're holding me in contempt.
Mr. Brooks,
By
I'm not holding
removing
you
me
in
from the
contempt for
courtroom.
the second time here, and I've
Your
also
Honor.
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with all
Mr. Brooks, I
respect-
need you to stop talking.
With all respect, in Illinois versus Allen.
All right, Mr. Brooks continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this court
trying to
that
understand,
he
Your Honor.
wants to disrupt these proceedings, even
That's
in
not true.
mild manner tone
That's
of
not
voice.
true.
I've
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
the standards
because
of
it
form and
doesn't.
civility, and one of the
doesn't.
bedrocks is that he
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that-
remove him to the next courtroom so that I can go through
It does
proper
not state-
advisements with him without being
It
interrupted.
does not
We'll clear
state
the courtroom
that
and
you
we'll
can be
resume
present from
once he
cameras.
is over there. Again,
It
I'll make
doesn't
the
state that
appropriate
you can be
findings when
present
he is
from
there.
cameras, or that you could be,
Yes, we're off the record.
or that you
until,
could be.
he's in the
Okay,
other
so
courtroom. I'll
you're
be
making a
stepping off.
tacit
Thank you.
agreement for something that I.
All right, I'm going to play another one since the chat is interested. Then we will go to another thing I was going to show after this part. Okay. Here we go. Let's watch another one.
They may unseal all of the search warrants in this case. The next issue I want to address is I want to make a record specifically as it relates to the restraints that the Sheriff's Department utilized during this case, given a comment made by Mr. Brooks when the jury was coming out the very last time. I don't recall if you said something about a stun belt or shackles or something to that effect, but it was inaccurate. I have asked the Sheriff's Department to provide photographic documentation of the shackles that were utilized in this case. The parties will recall the tables look a little different now because there are no table skirts on them. On all defense tables in the secure courtroom, there is a ring. It's really more looks like a rectangle that is attached to the leg of the table, and an inmate who's in custody but in trial, a soft restraint system is utilized, primarily so it's soft and not heard, and then it's attached to the table so that it confines the inmate to a small area with that table. Obviously during the trial, Mr. Brooks was able to stand. His hands were free, but I felt it important to have a thorough record of the restraints that were utilized. The photographs that have been provided are on a compact disc. They will be filed as Court Exhibit 3, but they will remain under seal. And that is because of the security concerns related to how the Sheriff's Department secures inmates during a trial. That certainly is an overriding interest, overriding any public interest to see what those restraints are. And I would just further note that during the trial, when Mr. Brooks would...
He has that side stare to him right there. He scared.
Be brought from the holding area into the courtroom. This courtroom was closed to the public, and that was really to maintain that privacy, if you will, or secrecy, if you will, regarding the restraint system. And so I believe it's important that that information not be released to the public. It will be available, of course, to the court and the parties. And if there is an appeal, any attorney that may represent you can certainly look at that, but it'll otherwise be under seal. So
Why would
the
that-
record is very clear on the restraint system that was utilized during this trial.
I have a question to that.
Okay.
Why is that remaining sealed, but everything else being open to the public?
I've indicated my reasons are on the record. I'm not going to restate them. So.
Well, I think that the public, if they're allowed to see search warrant information and things like that, then I think that they should know that it was a shock device on my ankles. That
there was no shock device.
It
on
was
your
a
ankle,
shock
sir.
device. I was told it was a shock device.
Mr. Brooks.
And
that's
it was
why
covered
I'm making
up.
the record.
It was covered up by a black cloth, so the jury purposely could not see it, and so that the public cannot see it. I was told that a chair had to be placed on my side so that no one can see that I was shackled with ankle shocks. I think the public should know that. The jury should have known that. That's what they were.
Mr. Brooks, I've made my ruling. Your
I
characterization
respect your
of
ruling,
those
but
as,
it should be noted.
Your
it should
objection
be
is noted for the record.
It should be noted that I had a shock device on my ankles. That's fact.
It
It's
is
a
not
fact.
fact, sir.
It is a fact. I'm the one that had them on my ankles. I inquired about what they were. Obviously, I'm going to require about what's being put on my body. I was told that they were a shock device, which I know how a shock device looks because I've been through this before in Milwaukee, so I know what a shock device is. It was clearly a shock device that was purposely not shown to the jury or to the public. Purposely not. And then now you're saying that it's going to be sealed. Well, why should it be sealed? The
All right,
public
Mr.
doesn't
Brooks,
deserve.
you're-
The public deserves
You've
to
made
know.
a record,
The
and
public
it's
deserves
noted.
to know about
And-
things pertaining to a search warrant, but not the fact that I was limited by a shock device. That if I moved the wrong way, I could have got shocked with all this
It's
voltage.
absolutely false that you
That
have a
is
shock
not
device
false,
on,
and
sir.
you know that it's not false.
Well, I have the photographs.
Well, show
that will be
where's
part
the
of the
photographs?
record,
Where's the photographs?
and they
You
will
just
be
said they would be sealed. Why do they need
from
to be
public
sealed?
view
Why
for
do
the
they need to
reasons
be
that I've
sealed from
already
the public?
indicated.
Why do they need to be sealed
Mr.
from
Brooks,
the public?
I need to move on to scheduling.
Can we move on to subject matter jurisdiction that hasn't been proved for the record?
All right, so
Can we move on to that?
Mr. Brooks, I really don't want to remove you from the courtroom today,
It-
but I need to move
I don't
on
want
to
to be removed, but you're not going to sit here and tell me on the record what was on my body when I was told what it was. That's inaccurate, and I I refuse.
At a
Your
later
Honor,
point in time, I
Your
will
Honor,
put.
I refuse to sit here and let you make an inaccurate record when you know that it was in fact a shock device. That's why I had the black cloth in front of the table so it couldn't be shown. That's
not
why I had
how.
a chair sitting on the side of me that was told needs to cover up the fact that I had a shock device on my ankles. And I think it's very, very, very unfair, and it's dishonorable to get on a record and not tell the truth. I'm not trying to dishonor you, Your Honor. I'm not trying to disrespect you. I'm not trying to disrespect your court. I just want the truth to be told. That should not be sealed. If everything else could be open to the public, then the public should know that I had a shock device on my ankles. That was purposely not shown to the jury or to the public. They should know that.
All right, thank you, Mr. Brooks. I disagree wholeheartedly with your
Well,
characterization.
it's not true.
Mr. Brooks, I didn't interrupt you. Please
It's not
don't
true.
interrupt me.
It's not true.
Mr. Brooks?
I'm quite sure there's cameras rolling right now because there are always cameras rolling. There's always audio on.
Mr. Brooks, I need
There's
to move on
public.
to
There's public in the
scheduling.
courtroom. I had a shock device on my ankles, and they purposely did not want to show that to you guys or to the jury. That's
Mr.
why I
Brooks,
can only move
I'm advising you.
here or here.
Mr.
That's
Brooks,
the
I'm
reason
advising
why.
you.
And I always had the chair right here. Everybody that came to this courtroom seen that I had a chair right here, even though I had no counsel. What is the reason for me to have a chair right here?
All right, Mr. Brooks,
Why
any
did I have a
further,
black cloth
any
in front of the
further
table?
interruptions will result in you being removed to the other courtroom
Okay,
because
and
you're
you
not
hold me
letting
in
move
contempt,
on
that's
to
okay.
scheduling.
Is it civil contempt or criminal contempt?
All right, one more interruption and you will go to the other courtroom.
Well, they need to know that.
Stop.
They need to know that. They need to know the truth.
I'm going to ask the state some questions. If you interrupt when I do that, you will be removed to the other
Okay,
courtroom.
remove me
All right,
then. Remove me
Attorney
then. It's
Basie.
not gonna stop the fact that they need
All
to
right,
know that a shock device
he's
was on my
interrupted.
ankles.
I'm sorry, everyone. We'll have to clear the courtroom. He will be removed to the other courtroom. I'll
That's,
make the
that's
appropriate
fine. Tell the
findings.
truth, though, Your Honor. Tell the truth. I had a shackle.
Lieutenant.
I had a shock device
Captain,
on
can
my
I
ankles.
please see you? We're off the
For-
record. Continued to be disruptive, the court would remove him to the other courtroom. It was my sincere hope that
Lori Vallow had a shock device on her. I believe I recall that Lori Vallow Daybell, because she got out of hand and they put something on her. So they may do that sometimes. So if somebody gets out of hand, they'll zap them. But with Brooks, they didn't do that with him. There either wasn't a shock device or they were concerned about the appeals. So they want to make sure any appeal he would try to do would fail. But yeah, he was being manipulative there. He was trying to stir a reaction, right? He's trying to get a reaction, and she's being stoic and not allowing him to do that. Right? Yes, Lori. All right, and now we'll continue.
that would not need to take place today. I gave him the final warning, and then I indicated I would be turning to the state to ask them some questions, and if he interrupted that process, he would be removed. He immediately interrupted that, and so the courtroom was closed. He was put into the other courtroom. I have confirmed that the audio and visual technology is working. He can hear, he can see, at least the other individuals in there confirmed that that was the case. He was audible for a little bit when I first went on the record, but he continued to be disruptive, and so I did utilize the mute function of the technology so that I could make an adequate record. Although this is really a scheduling hearing today, I will make a finding under Illinois versus Allen that his conduct was did disregard the elementary standards of proper conduct, of decorum and courtesy. He was disruptive. He interrupted multiple times and challenged this court when this court was making a record regarding the restraints that were utilized throughout this trial. I'm not going to do it today, but I will at a later point in time. Perhaps after scheduling, I will have a deputy testify regarding the restraints that were utilized so that there is a full and complete record about what was utilized and what was not utilized throughout this trial. It is absolutely false that a stun belt of any kind was used on Mr. Brooks. I don't know if he's receiving that information from other inmates. But that was not utilized in this case. It was a soft leg restraint setup, if you will, where he was shackled his ankles with the soft restraints and the soft strap so that it did not make noise. That was all attached to the table, and it is absolutely true that there was a black table skirt on the tables, both the state's table, the defense table, in this courtroom, despite Mr. Brooks believing that it was not done for his benefit. It was to shield that information from the jury. It's also true that at all times when he has been brought into court, it's been before the court has been open to the public. If this court needed to remove him to the other court.
Nan says, I remember that Sarah was going to either a shock vest or an ankle thingy, and she wanted the ankle one and wear a skirt so her scar could be seen, but I don't remember that happening because she got a lawyer. Yeah, I don't know. I've not heard of that. Thank you for letting me know, but yeah, I certainly, with the lawyer being there or not, can certainly determine certain factors. Yeah, thanks for the information.
Courtroom. It was also done with the courtroom closed to the public. That was, of course, a security decision made by the sheriff's department. They are in charge of his security as well as the court's security during any court proceeding in this courthouse. And it was their discretion and decision on what restraints would be utilized. And again, I'll go through that later and have a record made of what was utilized, including having one of the deputies identify what's on the exhibit. I'm not going to show that publicly. Again, there are security reasons. We don't, frankly, need inmates doing research or the public doing research on what these restraints are. There's an important security aspect related to keeping courts safe, keeping inmates safe, and that is why I'm sealing that information from public view so that their protocols and practices have that, frankly, veil of secrecy. It's important given the security issues. It's a law enforcement function, and that is my decision on that. As far as Mr. Brooks being in the other courtroom, again, I did that pursuant to the authority found in Illinois versus Allen. I did not hold him in contempt. Frankly, because it's a scheduling type hearing, I could simply have him taken back to the jail and he could appear by phone, but I've chosen to have him appear by video and audio means from the other courtroom. With that, I am going to address scheduling. I will be asking each party in turn how much time they believe they need to present their various sentencing remarks and whether anyone will be speaking on behalf. So I'll turn to the state first.
Thank you, Your Honor. To date, we have indications from the victims or their families that 36 people would like to either have a statement read or they'd like to read it themselves. We have approximately 5 to 10 others that would like to submit one in writing, which obviously wouldn't impact the time that we would need on the sentencing date. I would think that the state's comments would be between a half an hour to 45 minutes in total. So we're looking probably at about 4 to 4.5 hours. We will need some time to rotate victims out of the courtroom as they come in and to speak, because we can't fit everyone in the courtroom at one time. So we'll need to get one set in, get another one to room 115 so that they can hear what's being said. So we're thinking 4 hours, and speaking with the families and the victims Wednesday after the verdict. I think there's a strong desire to have the sentencing before the anniversary of the parade incident, and that obviously is November 21st. In checking with people, November 15th, 16th works for everyone. Specifically, the 16th works for everyone that would like to talk. I know that this court obviously has court calendars. I do have other dates that would work. Unfortunately, those go out to the end of December, end of November, beginning of December. But again, I can't emphasize enough, there are a lot of families who are leaving town the week of the parade, and I think the general consensus would be, it would be nice for them to have some finality to this before they leave, so that they're not around here at the time that a loved one was injured or killed.
By any chance, did you have an opportunity to look at my calendar and some of the jury trials and talk with your colleagues? I mean, one of the cases, for example, I have on the 15th is an attempted homicide trial. I don't know if that's going to go or not, but just like this court gave due attention to this case, I need to be mindful that that case has been scheduled since June.
I did not. I received these dates, although I believe that they were probably sent this weekend. I did not check my email over the weekend, so I did receive them this morning, and unfortunately I did not take the time to do that. We can certainly look right now. Do you know who's handling that attempted homicide from our office?
I believe that's Attorney Sitzberger.
Okay.
There's other cases as well, because it's rare that I wouldn't stack trials,
Right.
and so there's also another serious felony matter with Attorney Thurston for your office. That one was scheduled in August. I have another one with you,
Yes.
Attorney Basie. I'm just looking at the number of. Looks like I have 8 different defendants, many more cases, but 8 different defendants scheduled for jury trial on the 15th. The other thing is on the 16th, our CJCC has a very special meeting. I'm still the chair of that, and that is an anniversary of the CJCC that I do not want to miss. So not that I couldn't work around that, and it's not that I'm not willing to change, my calendar in any way that I can.
I can tell you, Attorney Witchow did reach out to Attorney Sitzberger. He indicated, and he said we could put this on the record, he's 98% confident that that will resolve the attempted.
I'm not trying to interrupt.
Go ahead.
You said, when is this supposed to be? Because I'm definitely gonna need a little bit more time than the 11th.
Mr. Brooks, I've made my decision. The sentencing will be on the 15th and the 16th of November. Anyone who wants to appear by Zoom on your behalf, you must file a request in writing no later than noon on the 11th. The same is true for the state. Everyone needs to be specifically identified so that I can make the appropriate approvals, and only those individuals who I specifically approve to appear by Zoom may be on the Zoom. The Zoom information can't be passed out further. And I'll create a special Zoom for that, and I'll make sure that I work with Teresa to do that and get that information when I approve that to the parties.
Your Honor, what if I'm placed on a protocol per the jail? What if?
Mr. Brooks, that's between you and the jail at this point. If there is something you need to first go through them. I'm not going to step on their toes with their protocols. I'm sure they'll understand this is a very important sentencing for you and make certain accommodations. They've done that throughout this case. I trust that they will do that as they determine is appropriate.
They haven't done it for the past week when I went on a protocol without even telling them anything suicidal in nature, and I was still placed on a suicide watch protocol.
I understand that, sir. I need to move on because I do have calendar this afternoon, but I want to have Detective Kibler come to the stand. Hibler.
Your Honor.
Deputy, what did I say? Detective, did I give you a promotion? Sorry. All right. He's going to come on up to the witness stand. I'm going to swear him in, and we'll go from there.
For the record, may I respectfully object to your ruling, Your Honor?
It's noted for the record. All right. Madam Clerk, swear him in, please.
For the record, may I respectfully request a legal reconsideration
All right,
of your
Mr.
ruling,
Brooks,
Your
I'm going
Honor?
to have to mute you because I need to keep going, and I can't have this disruption. Go ahead. Raise your right hand.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you, sir. Have a seat. I'll let you put your name on the record so I don't get that wrong. And so go ahead. Please state and spell your first and last names.
First name Nicholas, Nicholas. Last name Kibler, Kibler.
All right, thank you. And you are employed in what capacity with the Sheriff's Department?
I'm a deputy for the Waukesha County Sheriff's Department.
There's something going on here to show. Let's see. Let's go this way. All right, it looks like there's a chase going on right now. It looks interesting. So with Shots Mary Toodles. Yeah, with the courts can run very well without Brooks present messing up everything. Because every time he likes to go and do something, he causes everybody a problem. He gets very frustrated in the courtroom. He has all these different rantings and ravings, but when they have him in the other room, they can get things done. They usually can't get done without that, with him in there. I think Doro did the right thing by taking him out sometimes. All right. Do they find the car, or is it just sometimes with these chases they don't always have the vehicle you could see? Yeah, it's just a little bit. I don't know. Are they stopped? I'm not too sure, because I saw for a second. Yes, a chase. Yes, I used to watch chases to help me fall asleep. I'm weird. I know. Oh, I love watching chases. I love watching them. Yeah, it looks like it stopped right there. It's I don't know if they hit something. It's just yeah, it looks like that. Oh, it looks like they went through the fence. I guess there was a fence there, and they're just like stuck in a rut right there. All right. Or they're trying to move. I don't know. This looks like it's a frozen vehicle. The police usually swarm in and catch them. Okay. Yeah, it's difficult to see, but what's there is just this. Okay, it crashed into. Okay, it crashed. Oh, okay. It crashed into the gate, into the fence. Alright, it crashed into the fence. Your discretion is advised, just in case things get ugly. Okay, so, alright, let's see if it's going to get out of hand or not. They have their guns drawn. We don't know if they're alive or not, or what's going on with them, or they're even in the vehicle. And they turned away, and they need to go back to the other scene. Okay, so bird's eye view, and are they arresting him? Or is it somebody that got knocked out? Okay. Doesn't seem to be, is it I'm not too sure exactly what or where the person is, if they were in the car and they're just not either they're not alive or out of it, or if they got out. Maybe they got out the vehicle and they're on the loose. Maybe that's what happened. Sometimes they could hide within houses and different. I mean, not houses, but they could hide within yards and stuff. Let's see. Let's do this real quick. Alright. Yeah, smash that like button. Hello there, G, the star filled with all the gold and diamonds and gems. Thank you. I'm your gem. Thank you. So this is in Los Angeles County, by the way. This is in Los Angeles County. And the location's directly up on the screen. Okay. Yeah, so the diamond filled with gold and rubies and with a supernatural power to it that the most experienced space wizards only have access to. That's what you are, G. Good to see you. All right, so G, we were looking at some. There's a chase going on. Okay, G, understood. There is a chase going on, and they're looking for the person. All right, it's that must be what happened, I suppose. My Queen of Diamonds, we are watching a chase in LA, and it looks like they're appearing to be looking for the suspect. They crashed into a gate, and they're looking for something, so they must have ran off. That's what we're doing at the moment, and it is a live chase. And that's information I can gather. Oh, alien space and scan, love it. Yeah, thank you. And where is this? Yes, it is precisely in the Los Angeles County. That's where it is. And yeah, I see if they have the information. Yeah, so it is. It looks like they're searching because the person must have gotten away, and they have chases out here all the time. Okay. You're welcome, G. Yeah, it looks like they're looking through every crack, every little spot. They're trying to find this dude. Yeah, it's so dark, and in LA in general, they don't always have some proper lighting sometimes because of their. Not that they don't have proper lightings in the street, but in LA they have a problem with many things. And they have problems, for instance, with some like street lights don't work, and they have some homelessness going on. So it's not always a nice Candyland. It's quite the opposite sometimes. But so yeah, it looks like to me it looks like dark streets, maybe normal, maybe not normal. Because it looks like the person hit the gate, hit the fence, and they went off somewhere. And the helicopters are looking. It can be very difficult. Lori, I get chases in my city, I would think, as I hear them. I don't know if they're live streamed. I certainly hear there's all kinds of stuff. I mean, if there was like a police streamer out here, I certainly would restream it because we would get a lot of content in my city. There's all kinds of activity going on around the area, from what I can hear. And from what I see on the news. So yeah, I definitely I've seen it before. Like for instance, I've seen like they'll zip down the street. All right. Oh look, they're going looking inside there. Is he in there? Scared. Okay. They're yeah. So. Definitely, but I don't know if it's even live streamed where I am. There would certainly be police scanners for the city, but it wouldn't be. I don't know if there's any streamers doing it. Like over in LA, there's tons of people in LA doing it, streaming. Yeah. Okay, and you have. Yeah, I will, shout out to their dedication for looking for these people. Hilarious G. All right, G says Joey from 90 Day Finance is from New Orleans. He says they're known for strip clubs. Is that true? Well, they certainly have a lot of those down here, but that's one of the things it's known for in some parts, especially I'd say in the French Quarter and other areas. Yeah, and they also have, back from many many centuries, they have had stuff like that going on. It seems to be a party city, if you will, and there's lots of partying and other types of things like you mentioned as well. It was even dedicated in the Wax Museum for it. So it's certainly a wild city. Okay, and they're also known for a lot of bars, stuff like that too. Let's see, and then on top of that, with the food and the seasoning, it just gets spicy and fun for everybody. Yeah, it's and everything's all gold. All right. G said, "Well, I thought he was kidding. He was always going to them, and his fiance was all jealous." Oh, oh yeah, he certainly would be jealous of. Yeah, I would say that would be true, because it is known for their activity with that. Yeah. And G says, "The bars I figured and food they are known for." Yes, yes, and yeah. It's like a chat's being humorous, also. All right, it looks like the chase is over with. The chase is over with, and I don't know if they found him or not, but they ended it. But their biggest asset is the alien spaceship. Oh, thank you, G. Thank you. Yes, the biggest asset they have is the alien spaceship. Mary Toodles want to throw in that there's museums and other things like that it's known for. But yeah, architecture, music. Yeah, but it was a chat being funny. Yeah, it's so good thing I didn't live, especially there in high school. I was rowdy enough in small town Oregon. Yeah. Now we have some grounds to play. Or playing before. I was playing grounds because I was helping Bubbles out, and that was the thing that popped up on the screen, and then chat was very interested in it, so I was. And yes, Thoreau-Brooks is not my favorite person, but we do play all kinds of different trials. And this is one of the trials that we've been focusing on recently. But yeah, so I'm going to play some more grounds. I know that we certainly like that. Yeah, shout out to Mary Toodles. I'll tell her when she gets back in here. Yeah, they were known for even that said the Wax Museum had all about it. Look, I'm going to be serious here. I'm going to show you all the Wax Museum. I'm serious. We're going to go there. Okay. Grounds. All right, this is the Wax Museum, and there's some stuff in history that wasn't too nice that happened in the city that, like this slavery and stuff. So yeah, as I said, it's all true. It's all true. Like that lady right there in the attic with the slaves, she was real. She was a serial killer, and she fled to her to France. Was never seen again. That was actually true. But this right here, this scene right here is a scene of some prostitutes in the city fighting each other from 100 years ago. This was a part of the Wax Museum. Yeah. Thank you, Alien, for playing Grounds. I didn't come in earlier. I didn't see you were on. I just dropped my sister home, and they came here for a late brunch. Oh, okay, G. Yeah, I was on about an hour ago. Yeah, scared. Okay, so yeah, that was them fighting each other. This is a Cyclops thing from a horror movie. 'Cause I like horror movie stuff. Okay, and let's see. Does this work or does it not work? No. Yeah, that's the only scene I could basically see. So there is this scene right here. The whole scene was these two women fighting each other, and there was this these sailors getting pickpocketed by them. So yeah, that was. I tell you, it's there's truth into the matter. That's when Andrew Jackson helped save the city from me when I was invading it, reinvading it in the 1800s. And I came back here, and here I am. But anyway, yeah, that's when he was defending the city in the War of 1812. These are some homies making some plans. Oh, gee, I like Stranger Things. Yeah, that is true. It seems to be more rare than the other ones. Maybe this is a joke, everybody. Maybe they're just more clever than the men, but that's a joke. But women are very clever. They are, but still, I don't. It's probably true with the statistics, but there are more men usually than women. This is a scene, but yeah, gee, I'll tell you about Stranger Things. It's based back in the 80s, and there's these supernatural things that occur, like aliens and stuff like that. If it's not aliens, it's something like that. And I've seen it before, but there's these supernatural things that happen, and these group of young kids do go on like an adventure. I'll explain more about it, but that's basically to summarize what it was. All right, so this is the Casket Girls is these women who were from France that the king sent here because the men didn't have any women here, so they sent the caskets out. They had these briefcases, right? But it's so kind of understand our modern terms, and they would come out here and they thought they were hiding vampires in those boxes, so they called them the Casket Girls. 11 to 17%. Okay. My sister was binge watching it yesterday. My daughter was binge watching it. Apparently, they went to Broadway shows 6 times. My sister. Oh, that's cool. That's cool. Yeah, I recommend you watch it. I think you'd like it. It's sci-fi stuff. If you're into sci-fi things. This was a event that occurred, and this woman, she was abusing the slaves in the attic, and they chased her out of the city. A mob of people chased her out the city, and she went back to France. But yeah, she was like a serial killer, very evil. So yes, this was a true story that happened, and it was wrong. And thankfully, that is over with. This has to do with voodoo when they were doing it's the African religion that they had. It was just an example of maybe 200-300 years ago people did stuff like this. But there's still voodoo in the city, but I don't see people like out in public doing that now. Yeah, and it's also an artistic expression. This is a horror movie scene, right there. All right. Yeah, that was your childhood, right? Yeah. So yes, I told him my best friend died of word of age 48 was fantastic, and she actually owns the company, and her aunt now runs the sci-fi related. That is really cool, G. Very cool information. But Google also says they may also undercount it because they often used methods of poison like they are less suspicious, tend to kill people they know, like family patients. Oh, okay. Just like the story we talked about. We talked about something like that before. Okay. So that's a good point. As I said, they're very, very clever. Like Burrow Brooks, he's a moron. Like he just does it out in the public. But like say like a they had someone will have a poison ring and just dump it in the drink and no one knows. So yeah, it's just Brooks is just a blind rage. All right, so Stranger Things, and then we'll get back to grounds. All right, so I don't know if there's going to be any spoilers or not. There could be a spoiler alert. I don't know, but here it goes. Stranger Things, a science fiction horror drama series that was serves as a love letter to 1980s pop culture, primarily centered around a group of friends and family in a fictional town of Hawkins, Indiana. It reminds me of It. That's what it reminds me of. For the clown thing. The narrative weaves together themes of friendship, family, coming of age, and battle between good and evil, and characters confirm supernatural, mysterious mystery stemming from government conspiracies. All right, Michael, thank you for your 45-minute visit. We are honored to have you on board. All right, there could be spoiler alerts, but here it goes. Story begins in November 1983 when young boy Will Byers goes missing under the mysterious circumstances. His disappearance sparks a search that unveils dark truth about seriously idiotic town. It is the site of a secret government experiments at Hawkins National Laboratory. Okay. Across the seasons, the characters grow while facing increasingly dangerous, scared incursions from upside down, led by Vikenna. You're kidding. You're kidding. They learn to harness their individual strengths, especially Eleven's powers and Will's unique connection to the hive mind, highlight the power of love and friendship in the face of immense evil. Right. So now going back to grounds.
Record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law. The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech. I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart in my opening statements, and now I'm going to speak from the heart. What you won't hear me do is argue facts. And the reason you won't hear me argue facts is because I believe that it takes away from what should be recognized. The tragedy of this event. It should be recognized. Trying to argue facts of this, facts of that, I'm not gonna waste your time doing that. It's a little emotional. I apologize for the long pause. It's hard to keep everything together emotionally. And honestly, I don't believe that I have any more tears left. It's been a hard year. For the families, mostly. And that should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. It's a lot of people that are healing, that are attempting to heal. That opens the door to talk about forgiveness for a little bit. With every healing process, there comes a forgiving process. It's not an easy thing for anyone. What you've been hearing from the prosecution, and not to take anything away from them, but let's call it what it is. You've been hearing a lot of rerun. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying it, the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing it? That's what's been happening. Rerun. Over and over and over and over and over and over and over. Attempting to make things stick in your head that simply aren't true. Why do I say, what am I saying? I say, look at the testimony. You know, the theme from the prosecution here has been intent, 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 intent. We all know what's been said. We all know the picture that's been painted. Even the prosecution said themselves. How can you look in somebody's head and say, this is what they intended to do? You know, for a year, I've sat and gone through this. Feeling so powerless. You know, letting other people run with the narratives. Sitting back helpless while other people paint a picture that has zero truth. Zero. I understand about healing myself. tragedy, pain, all that. A lot of it, there's no need to get into. I myself in my own life have had to do a lot of healing. As a man with children myself, I find it hard to believe that anyone who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act. I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn. While attempting to alert people of their presence. Which brings me to more information that I believe that you should have been privy to. And I'm sure that the prosecution will beg to differ, but the fact of the matter is, the vehicle in question, make and model of 2010, Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection, misstatement of the facts, facts not in evidence.
Was in fact-
Improper argument, Your Honor.
Sustained.
Was in fact recalled. Was in fact a class action lawsuit against Ford
Objection,
for those
facts not in
models,
evidence,
for
Your
those
Honor.
model vehicles.
Sustained. The juror will disregard.
Information that you should have been privy to, that you weren't allowed to be privy to. Why? I don't know. That information, malfunctioning throttle bodies,
Mr. Brooks, move on.
it's information that you should have been privy to. Vehicles that malfunction and accelerate not being able to be stopped.
Objection, that is
It's
completely
information,
inaccurate,
it's
Your Honor.
There's an
information.
objection. Hold on.
Strike.
Go ahead.
Move to strike statements by Mr.
Sorry for the
Brooks.
interruption.
They are facts not in evidence, Your Honor, and it's a complete misstatement.
Sustained. Strike
How's it a
the-
misstatement when I have the information?
Mr. Brooks, move on.
This is information that I feel like you needed to know. You should have known. Information that was taken away from you. Why? To prove a case? Information that you definitely should have been privy to. DA says the defendant has an utter disregard for human life. Utter disregard.
Yeah, and G says, I think so. He's got an expert to say car was old and malfunctioning to counter stakes expert. Yeah, because of these things he's bringing up about the horn, beeping the horn and stuff. I mean, you could have had a professional argue this stuff for him, and it could have gone in a, you know, he probably still gotten jail time, or maybe just the same amount of jail time, but it could have been less or different if he had a professional do it. He had an affidavit from Zach Bacon's SUV was possessed, but judge wouldn't allow it in. He had an affidavit from Zach Bagans that his SUV was possessed, but okay, he wouldn't let it in. We'll tow you car from heaven to hell. Okay. And no, I agree. He would have had a chance of a lighter sentence. Oh, okay, G. Thank you for your opinion about that. Okay. So I was basically onto something. All right. Yeah. So it's all with the the way they're trained to do it. That's what, rather than doing it himself. I mean, there's lots of things that, for instance, the rap video that was shown, that wasn't even supposed to be played. But he didn't know from what the attorneys agreed on, the state attorney and the other attorney agreed on before they did it. So that's another thing about him. Like, he could have not even had to avoid all that. You know, it would have been better. So in his situation, he should have had someone else defend him, but he's so into himself and into the spotlight, just like with the original accident, he was his own worst enemy. Oh, okay, Michael. Okay, thank you. All right, so continuing.
For human life. Not realizing that they're talking about someone that has children. Talking about someone that watched their children come out of the womb and be born into this world, cut the umbilical cord, held them before their mom even did it. Moments that I'll never forget. And yet they say disregard, utter disregard for human life. They made reference to a rage, as if they were, or if this particular DA was right there, standing right there, as if this DA is a psychiatrist. I said to myself,
Yeah, a G meant, and I meant a lighter verdict, right? And very well said, Lori. I agree.
what rage? What do you mean rage? How can you characterize that? How can you have the audacity to diagnose what someone's brain is? Where it's at, what it's thinking, why it thinks the way it does? DA makes references to blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage, the supposed intent to harm and kill, and it doesn't kick in until well within blocks. And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger, then why weren't people immediately harmed? Why would someone with intent to kill and rage try to alert people of their presence, repeatedly honk their horn? You heard a detective if you recall, testified that the vehicle that he observed was not only honking his horn, but was not speeding. So where does this rage kick in? Where does this insatiable intent to kill kick in? I speak as someone who's known someone for years. Which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
Objection, fact, not in evidence.
What if the driver of the vehicle was unable to stop the vehicle? Because of that fact, what if the driver may have panicked?
Yeah, G, I agree. And the look at the freeze frame of the frown. You see, with Darrell, notice the pauses he does. The pauses that's a theatrical thing he's doing. It is that gets people to stop and think about what he's saying. That's a tactic he's using. And yeah, I mean, his case he's talking about could have been presented with a proper attorney, and there could be a lighter verdict. You know, there could have been more light than the current situation that he was in, but he just dug his own grave. That's why they always say to never defend yourself. But there are some instances where you have people. One instance in the Treehouse trial where the person defended themselves and it worked. I reiterate, Darrell, 6 people died and 62 injured. All right. And sometimes, like G and I have talked about before, with sometimes people are going to go to jail either way, but they could get less time. Like in the Donna Adelson trial, she could have gotten a different sentence, but they're trying to get her out completely. It's like sometimes you got to go through the fire. It's scripture, right? You go through the fire, through the flood, through the famine, but people come out. So in a situation, people might go to jail either way, but they could get a lesser verdict than the other verdict. They don't seem to always understand that. So they, with an attorney, a good attorney, they could get a different situation, but they usually are their own worst enemy. Right. That's why I am extremely beyond blessed for the spaceship law team we have here. Very wise information. All right, so we're going to continue with the frowning Brooks.
Does that make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people? DA played exhibit 17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck. Was someone who had this intent to kill, this rage, as she says. If that was their intent, wouldn't they have taken the opportunity to hit as many people as they could? Target people, mow down people. Reference was made to this vehicle, the damage. Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. You've heard testimony about hearing loud crashes and things of that nature, but the DA wants you to believe that this all came from people. Evidence doesn't support that. So I go back to trying to wrap my head around everything that's happened in the last year. Praying for those families, praying for the people that tragically lost their life, because that should not be lost either. The fact that there was lives lost, and all the emphasis has been put on the alleged defendant. And the people have been disregarded.
Hey Todd, good to see you, buddy. We saw a chase earlier. We watched it on here. They were looking for the person, then they ended the stream. So they eventually, we don't really know what happened with that one, but yeah, we watched a chase in LA that happened a little while ago. Yeah, and we're giving some analysis on this case right now. That's what we're doing at the moment. So good evening, Todd. I hope you had I saw you a couple of days ago, but I may have said this already, but I hope you had a good Thanksgiving, and hope everything's going well with you. Thanks for stopping by, telling us hello.
Makes me wonder, does the DA even care about those people? There's been prayers going up every day. It's been suffering on both sides. It's been threats, hate mail. Because of the narratives that's been put out there, the misconceptions that have been put out there, the lies that have been put out there, lies that have caused my children not to be able to go to school, to be bullied, for my mother to have to leave her home and stay at a hotel because she's afraid for her safety, because she gets hate mail shoved through her mailbox. My nieces and nephews to fear for their safety. And what's been equally hard is not only having to answer the questions from my daughter, who was 7 at the time, my baby girl, who was 7 at the time, is now 8. Attempting to answer her questions that she's asking, and still continue to shield her from what she sees, what she hears. Having a newborn son that I haven't even been able to meet. Haven't been able to hold, touch, kiss. having to navigate everything that comes with this whole situation. While still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell, especially during lights out, alone, where it's just you. And just been praying and asking myself, how could this happen? Not just for the people, but for everybody involved, the community too. How could this happen? How? The hardest questions you can ask is those that don't have an answer. No matter how much thinking you do, no matter how much you try to look at it from different perspectives and listen to other outside perspectives and listen to people that you trust and that you love, still coming up with nothing. But to think for 1 second, one question I never had to ask was if this was intentional. That's something that I never asked once. Because I know it wasn't. As a matter of fact, it never even crossed my mind to even attempt to ask myself that, because I know it wasn't. And I know sometimes during this trial probably doesn't show. Maybe hard to believe. But trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine. So again, I go back to all these exhibits. Go back to everything that's been shown, everything that's been testified to. Everything you've heard during this whole process, this trial. And again, I say the same thing that I said earlier. Same thing I said in opening statements. I'm not reading from any paper, any books. Everything you've heard in opening statements, everything you're hearing now is from right here. Everything. You have the decision. You and you alone, all of you. You have the decision. I'm sure you've taken a lot of notes during this process. Some days are longer than others. A lot of movement in and out of the courtroom for various reasons. Remember the power that you have. Don't for 1 second let it be taken away from you. I can never understand the position of sitting on the jury in something of this magnitude. So I'm sure there's a lot of pressure. I pray that the right decision is made. The right decision. It's almost like that a message, well, not message, but that writing when we're in our vehicles and we got that rearview mirror and it said things are closer than they appear. But it's also another way of saying sometimes things aren't as they appear. I can't speak for anyone else, but me, myself, I believe in Jesus Christ. That's how I was raised. That's what I believe in. None of us are perfect. But I try every day to make sure that I acknowledge him. That's why every time I step in this courtroom, I have my Bible with me everywhere I go. I even read it on breaks, recesses. This is not something that started at the beginning of this incident. This is something that has been instilled in me since I came out of the womb. This is how my family lives their life. This is how we was raised. For whatever mistakes that I myself have made in my life, I've made peace with God. Made peace. I'm happy to say that my conscience is clear. And because I believe, I trust him with my life. Nobody will never know why it was his will for this to happen. A lot of lives were changed that day, mine included. God's way is not our own. And no matter how much sometimes we want to question, we have to have faith. Look inside yourself. Look inside yourself and make the right decision. Look inside your heart. You have everything in your hands now. Everything. Do what's right. Do what's right. Don't let the smoke and mirrors take away your power. Don't let the theatrics take away your power. Each and every one of you has a decision. Who's right? Make the right decision. It's hard to think about my younger kids getting older and at some point having to explain everything to them. Kids don't stay kids forever. And nowadays, kids is frankly a lot smarter than we were when we was kids. I'll tell you that much. I got a letter the other day from my youngest daughter. And she's still learning cursive right now, so she's the best writer when it comes to cursive. She'd rather print. She said, Dad, and this is from the letter. She said, Dad, why are people saying all these mean things about you? I haven't read the rest of that letter yet. The rest of that sentence said, that's not the dad I know. Throughout this year, I've been called a lot of things. And to be fair, I am a lot of things. A murderer is not one of them. Never has been, never will be. So before I close my statements, just want to say, open your hearts. Go inside yourself when making this decision. Have no fear. Pray and do what you know is right. you know is right. Think about everything you've heard. Think about everything you haven't been privileged to hear. Think about the whole entire picture. And above everything, whatever you decide, make sure you yourself can live with it. Make sure you can live with it. That's the magnitude of the power that you have. Just like this tissue is in my hand, this is everything. You have everything. Be at peace with what you decide. Had no regrets. Don't let this decision weigh on you after it's over. Hopefully we got a lot of living ahead of us. Lord willing. Don't look back and kick yourself in the behind. It's been about 3 weeks with you, and it took a lot of courage and a lot of guts to pause your life for this. To put important things on hold, to basically stop your life. You should be commended for being able to sit up here with this amount of pressure. I want you guys to know that's not lost on me. I'm sure it's a lot. And you all should be commended because it took courage to do this. I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now. And you guys had the guts to do it. Thank you for that. Thank you for taking pretty much a month and setting it to the side for this. I know it's probably not proper, but you guys deserve a round of applause if you could get one. Thank you guys sincerely, and I know, and I have faith, and I trust that guys know what's right. Ladies and gentlemen, I don't think it's fair to just say guys, but I believe in your heart you know what's right. Thank you.
Nan says to Mermaid, I read your comment above. I'm so happy that you're trying. My mom and dad didn't try, but they both died too young. Because of it, everyone that knows you wants you to be alive and well. That is true, Nan. Thank you for your kind words to Mermaid. Very sweet. All right. And yeah, very good commentary chat with this case as we watch different random scenes from it. We'll now continue. Seeing we have an audience of enthusiasts with it, which I'm also enthused by it too. All right.
Prove subject matter jurisdiction on the record, Your Honor.
I'm not addressing that any further than I've addressed already, sir. There's a written decision. I remind you of that.
In that written decision, did I receive, well, actually I didn't receive anything. Was there copies made?
Mr. Brooks, I'm going to ask you one more time. Are you prepared with your closing argument? I'm going to have the jury brought out. There's no other legal arguments I need to address from you at this time.
I'm informed of what you're saying. I was merely asking, was there copies made of you said written decision?
Sir, my written decision has been filed into the record. That is done electronically. You were provided with a written copy previously. Are you asking for another copy of that, sir?
Yeah, because I don't have it.
As a courtesy, I'll have my clerk print off a copy and provide that to you.
Is it proven subject matter jurisdiction?
Your objection to the lack of jurisdiction has been noted repeatedly on the record. It is a meritless argument. I've indicated that in my written decision as to why there is subject matter jurisdiction, and I will continue forward with the final stages of this trial, which I hope include your closing argument and then the final instructions to the jury.
I would hope it proves subject matter jurisdiction on the record too.
All right, I will instruct the jury to come out. For the record, the written decision is once again being provided to the
I
defendant.
accept for value and return for value this document as it is not based in lawful law. And it does not prove subject matter jurisdiction whatsoever. Refers to some complaint that was filed in the name of a trust, not my name. Were you aware of that, Your Honor?
Mr. Brooks, the jury has been asked to be brought out. I mean, I've requested that they be brought out. They're on their way.
Were you aware of that?
Please be prepared with your closing argument.
Were you aware of that, Your Honor? Or is that a tacit agreement that you don't have to answer any questions as a public servant?
All rise.
So that is a tacit agreement.
Record to reflect the jury is coming out. Thank you, everyone. Please be seated. Go ahead, sir. You may begin your closing argument.
I'm not ready to begin closing arguments.
So this is your opportunity to provide your closing argument to the jury. Please start. I've started the timer of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why. The jury deserves to
Mr.
need
Brooks,
to know.
this is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they have not been informed of their truth, their rights, and their duties.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30-plus pages to read.
Did you inform
They will
the
be
jury?
informed of the law.
Did you inform them that they can
Mr.
nullify
Brooks?
the law?
Mr. Brooks, you do not have that right to request that. And
Were
I'm
they
advising
informed?
you, one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr.
That they
Brooks,
are-
you
that
have
they
no
have
right
the
to
power.
make that argument to the jury.
It's true. They have the power.
All right, I'm going to excuse the jury.
They should know that they have the power.
Please rise for the jury. Thank you. Please be seated. Mr. Brooks, you do not have a right to request jury nullification directly from this jury. I direct your attention to the Bajurkas case, BJERKASS, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct or to request an instruction or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom, I was able to mute half of what you said the second time, and then of course you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
I haven't made any such choice, so you can't coerce me into a constitutional right waiver when I have not waived the constitutional right, and I will not allow you as a public servant to do that. I have not made a choice.
Sir, the time has come for you to present your closing argument.
Are you making a judicial determination that you're denying me a constitutional right in
I have
open
not
court
made such a
on record?
determination as of yet, but you can forfeit your constitutional rights
Under
by
what
conduct.
lawful law?
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to rights when talking about
In
closing
State versus
statements.
Anthony,
Illinois
the Supreme
versus
Court
Allen.
of Wisconsin referenced both that decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of those
the
that you just
reasoning-
named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed from the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument. So how's that same statute being used for something that it doesn't even refer to or pertain to?
Mr. Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is State versus Anthony, are two examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular defendant.
And that was to be present in trial, correct?
The right to present a closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by the constitutions.
Which I was denied the
I'm
right
not
to
prepared to
be
make
able to
that ruling
testify to.
here yet today, but I will tell you this, sir. The time has now come for you to present a closing argument. There will be no further delays.
It's
I will
a
not
delay.
be taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing
And
arguments.
you made that while
It is
violating
up-
my constitutional
Sir,
right.
please don't interrupt me because
Well,
you've now
you did.
interrupted me a couple of times.
No, once. So let's
Twice.
make that correct. Once.
That's the third time.
Okay, now you can say two.
So, Mr. Brooks, I'm advising you yet again, the
I
time
don't
has now
consent to
come.
being called
That's
that name,
another
Your Honor.
interruption. The time has now come for you to present your closing argument to this jury. You
And-
were brought back over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
No, I'm going to let them know that they have rights and they should be told, informed of the truth. It's not me
Are
trying
you
to
telling
give.
me, sir, that
it's
you are
not
going
trying
to
give.
let me ask you a
No, hold
question.
on. I'm not trying to give any
Sir, you're
jury
interrupting
instruction.
me and you haven't let me finish. So are you telling me that you are going to disregard my very clear directive to you to not bring up the topic of jury nullification?
That's not what I said.
That's why I'm asking you.
I don't understand that question because that's not what I said.
Sir, you may not argue jury nullification
I'm
to
going
this
to
jury.
inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have the. You just said on the record that they have the power for.
Sir, I direct your
you
attention
just said that.
once
Did you
again.
not just say that, Your Honor?
Sir,
You
the
said I couldn't
jury-
instruct them.
The jury
on
has
that.
the power, but not the right to nullify.
Right.
A
You said the
party-
power. You said the
Listen
power.
to me, sir. You're interrupting me once again.
So I'm going to inform them that they have the power.
Are you telling me, sir,
I'm
that
not
you are
telling you no
going
such
to
thing. I
disregard
just told you what you just said.
my directive to you to not raise the issue of jury nullification during your closing argument?
That's not what I said. You just read and said that they have the power to. That's what you just said, Your Honor.
Sir, State versus Bjerkus says and stands for the proposition that although the jury has the power of jury nullification,
They have the power.
no party has the right to argue for jury nullification.
I'm not arguing for it, Your Honor. I
In
just
that
want them to be
case,
informed. I just want them
Sir,
merely to be informed.
You can
That's
call
it.
it informing, making them aware.
Yeah,
Whether
they should be aware
you
of
are
the
not
rights.
allowed to make them aware of their power to nullify. That
How
is
can I
an
not make them-
improper argument.
Your Honor, how can I not inform them that they have a power? How
Because
can I
that
not
is not a
inform them
right
of a
that
power
you
that they
have, sir.
have? I'm not giving a new jury instruction.
That is
That's not
because
what I'm
there is
arguing.
no jury instruction for jury nullification,
Yeah, I'm
sir,
not-
because it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely attempting to inform them of the power that they have.
Mr.
That's not
Brooks,
against the law.
I'm advising you one more time. You may not raise the issue of jury nullification
I'm going
before
to
this
inform
jury.
them of the power that they have. I'm not
You are
giving them.
telling me that
I'm not
you
giving
are
them a jury
insisting
instruction.
on telling them about jury nullification. That's
That's-
what I hear you saying.
That's not what I said, though. Don't mischaracterize what I'm saying. You just read and said that they have the power. They have the power to do that. So how is
It's an
informing them?
inherent power that they have. They are not to be instructed on it. That is very clear in the law. In
Your
addition to, no, let me finish. In addition to the case that I just cited, I'd cite to you from the jury instructions, the law note on jury nullification 705. What that says, sir, is, I'm not going to read it all. It's many, many pages. But the bottom line is, it is improper for a court to allow a defendant or a defense attorney to make an argument or make the jury aware that they have the power to nullify a verdict.
And Your Honor, you just added this last night. That's why I had to sit there for an hour in the holding cell and wait for you to change the whole paperwork, because I brought that up. So you never intended for this to even be an issue.
Mr.
It
Brooks,
never was brought up.
If you
But
think
then when I
wasn't-
raised the issue,
if you
Your Honor, let
think
me
that
finish.
I'm not prepared to deal with an argument on jury nullification,
I didn't say,
then you
that's not what I said. That's
You are
not what I
missing the
said. In
mark.
all fairness, that's not what I said.
The record should accurately reflect that you were kept in that holding cell.
Why was I kept
so
in there?
that my clerk could finish
Adding a jury instruction that was not there.
76 verdict forms, and it's ×2 because there's a guilty and a not guilty
Okay.
for each. No, let me finish.
So
Or
how
you've
did
interrupted
so how did
me
I have why did I
repeatedly.
have to sit here for that where I could have just went to my cell and had it delivered? We had this
Mr.
at the end of last night before you called recess.
I'm not going to
we
debate
had a
that
whole
topic with
we
you
had a whole
further.
conversation about
Mr. Brooks, you
me
are
bringing up about the jury
defiantly
nullification.
disregarding this court. You
Here we go
can
with this.
roll your eyes
Here
at
we-
me
because
all
it's,
you want.
it's ridiculous, Your Honor. You just stated that they have the power to nullify
Would you
any
like,
law,
if you would like,
but then I
will
said
read this to you, sir, the part of the case that's important, but you're not letting me get a word in edgewise. I'm trying my best not to remove you to the other courtroom, but that is oftentimes what I need to do in order for this court to make a full record without you interrupting me. But you need to be fully aware that you may not raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going to disregard that direction, you will forfeit your right to present a closing argument.
under what lawful law?
Under State versus Anthony.
That it doesn't refer to that.
State versus Anthony
it
may
doesn't.
not have dealt with
It hasn't dealt with
the
closing
right
arguments.
to a closing argument, sir, but the reasoning
You just said it right there.
nonetheless is
No.
fully applicable.
No, you
because the more
can't
general
change the law, Your
principle-
Honor. You can't change the law. That's
I'm not
practicing law
changing
from the
the law,
bench.
sir, but the general principle.
I know you used to be in legislation, but you can't practice law from the bench.
Sir, I'm
You
not
can't do that.
practicing law from the bench.
You are if you're changing. Your Honor,
I'm not
you're
making-
attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument. Nothing that you just
So,
named. Not
Mr.
Illinois
Brooks,
versus
I
Allen.
would like to make a record. Would you please show the courtesy and respect for
I
me
will,
to
Your
do
Honor.
that?
I will.
All right. So looking at the Anthony case, all right, and that case starting at head note 7, paragraph 54 says the following, and you need to let me get all the way through it. We have recognized two distinct ways in which a defendant may give up his rights, waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there, I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dina case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture, doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus Allen, 397 U.S. 337. They went on, the court, that is the Wisconsin Supreme Court in Anthony. As previously noted, we have held that the right to testify is subject to waiver, not forfeiture, insofar as a defendant's inaction in asserting the right is concerned. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing the guidance from Illinois versus Allen and State versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor this ruling of mine, then you will forfeit your right to present a closing argument. That is my ruling.
I object to that ruling, Your Honor. I object to that ruling.
Are you willing to make a closing argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power. Again, I never stated that I was making a new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Not
what I'm
one time
telling
did you, hold on, Your Honor, with all due respect, I'll let you make your record. I didn't interrupt you.
Go ahead.
Not one case law that you just cited made any reference whatsoever to a closing argument. Not one. So how is me merely informing the jury of the power and the rights that they have, how is that a forfeiture of being able to give a closing argument?
Well, in addition to the cases I've just cited, sir, I'd also point you to State versus Bajirkis, 163 Wisconsin 2nd at 549. That's a Court of Appeals case from 1991. That is the first published appellate decision in Wisconsin to consider directly several issues relating to outside the presence of the jury after the case has been given to them. Now, in
Prove subject matter jurisdiction on the record, Your Honor.
I'm not addressing that. In creating a rule for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold up now. I'm the only one that has to be made rules for closing arguments, but not the prosecution. How is that fair? How is that balanced?
Mr. Brooks, I'm squarely faced with your defiance regarding the issue of jury nullification.
It's
that
not
is
defiance.
Requiring
It's
me
not defiance.
to address this issue and to tell you very
Your Honor,
expressly
I
that is the rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to that.
Your objection is noted for the record. But
May
my
I ask
rule
for a legal
nonetheless
reconsideration of your
stands.
ruling?
That request is denied.
May I respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling. For the record, may I request a legal or factual basis for your ruling? Not one pertaining to being present in the courtroom or testifying. One that specifically talks about a closing argument.
All of those requests are noted. I will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the forum for which an appeal would be sought, sir. I cannot answer that.
You referred to it before.
You would need
So
to
now I'm
direct your
confused.
appeal to
I'm confused, Your
to
Honor,
a court of
because-
appeals, not this court.
No, this is, I'm supposed to be in this admiralty court because you haven't, if we're under Article 3, then we should be in common law court. That hasn't even been addressed if we're in a common law court or an admiralty court.
That's a baseless argument, sir. I don't even
And
need to
what law and
address it.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Sir, I intend to bring this jury out and give you
I'm
an
informed.
opportunity
I'm informed of that.
to present a closing argument.
Yeah,
If
but
you
you're
violate,
also, you're
please
also,
let me,
but
sir,
listen,
you're
you just
interrupting me
made a
yet
rule.
again.
You just tried to put me under a rule that no one else was put under.
The circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't,
on
Your
the
Honor, that's
issue
a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the same rules.
Sir, the
It has to be
circumstances of
fair.
this case and your insistence on arguing jury nullification has resulted
I
in this
haven't-
court creating this rule.
I haven't argued it. I said that I wanted to inform the jury of their power. I never once said I'm going to make an argument. I'm going to give them a jury instruction.
You may not
never
advise
said
them
that.
or make them aware in any way that they have the power
And why
of
not?
jury
Why can't they be
nullification.
informed of their power?
Because it would violate the Bajorkas decision, sir.
Violate what decision?
All right, sir, I am going to bring the jury out.
And I'm going to inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare that your right to present
You
a
can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based upon
Then I make a
how I've
oral,
outlined that
oral
to
motion
date.
for a
I'm
legal
not going to
finding of
declare that
fact.
at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't
to
do that.
Present a closing
Under
argument.
what lawful law can you?
And then if you continue to
Under
interrupt
what
me,
lawful law?
you will be removed to the other courtroom as I complete
So I'm being
the
held in
instructions.
contempt again. Is it civil or criminal?
All right. Go ahead.
I apologize. May I ask the court to consider perhaps an alternative, and I fully respect the ruling the court has just made, and I understand the basis for it. We all know the defendant, in his petulance, will say jury nullification in the first 3 seconds the jury's in the room.
Objection
The-
to that.
Proper
I don't
thing
think
to
that
do,
I
I
should be
think,
talked
Your
down
Honor.
Stop
to.
interrupting,
I don't
Attorney
think I
Hopper,
should
please.
be talked down to.
Allow him to make his closing argument. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing argument. But we could at least try to, by merely objecting and the court telling the jury to disregard and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction. This court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence. And I think they will abide by that. So I know it's going to require effort for the court to allow this to allow Mr. Brooks to try and proceed, but I think we should try that or something similar to that in an effort to get through this next step, or else we will continue at this pace forever.
I'm certainly willing to try that.
It's about all we could come up with, Your Honor.
I mean, I'm certainly willing to try it in this courtroom, and if he disregards that, to excuse the jury and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
Agreed.
Your Honor, I object to that.
Your objection is noted for the record. That will be the course of action that this court takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in a blatant disregard of the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
All right, with that, let's bring the jury
For the
out.
record, may I respectfully request a legal reconsideration of your ruling? So is that a tacit agreement that you don't have to answer my objection, Your Honor?
I decline to reconsider.
I reject that ruling and take exception to that ruling, Your Honor.
Noted for the record.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
Denied.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue, Your Honor?
Denied.
For the record.
Go ahead, Mr. Brooks, your closing argument. Hold on.
So that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you sneak and have
Do you want
contact?
to open up the door to the other act's evidence of
That's
you
not
used-
opening.
No.
That's not
Hear me
opening the
out.
door.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. This witness, Detective Guth, I believe Detective Casey and others, Corey Runkle, and even Nicholas Kirby yesterday, this court has all had to stop them so that they didn't run afoul, or they've stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts evidence between you and this witness. And I have been very, very careful to make sure that doesn't come in. But if you keep questioning her about whether she's afraid or not, or why she wouldn't have contact or not, you are opening the door to that testimony. All of my rulings have been made to prevent what could be seen as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial. But you can open the door to that, sir.
It's unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness can get on the stand and lie on the stand.
Have you turned that document over to the state?
Come on, man. Y'all know that's not right. Y'all know that's not right.
Then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When did you receive the document? Hold on. When did you? I'm having you make an offer. When did you receive the document?
Okay, but I just want to state for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have. But
that's not true. That's a misstatement of the
that
evidence.
is true.
No.
She said it herself.
No, marking an exhibit is not creating an
No,
exhibit.
not marking the exhibit. She said
We're not
that
going to go
essentially-
down a tangent, sir.
All right,
I'm going
I'm
to
not gonna
focus
argue
on
with
this,
you,
and I'm
but
going to
it's
give
not
you the
fair.
opportunity
It's
to
not
make
fair.
a record.
It's not
All right?
fair. It's not fair.
When did you receive this document that you claim was sent by this witness?
It's not claim. It's for a fact.
Sir, it hasn't been established yet. I need to make a record.
So do y'all want
I
the
want
letter?
to see
Y'all want
the
the
letter.
envelope? What?
I want to see the letter.
Okay, so I gotta.
And I wanna
so now
know
I gotta
when you
bring that
received
in.
it.
Now I gotta bring that in. Every time, this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not, sir. There are proper procedures, and I
Okay,
want
well,
you to
that
make
was the
a
proper
record.
procedure.
If you don't make a record,
So
then
what?
I can't make a ruling.
It threw people off a loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop
are
it.
you aren't
Stop
even
it.
letting
You're a
me
public
ask the
servant, Your Honor.
questions.
I respect your courtroom. I
You
respect
do-
you. You're a public servant, though. Your job is to be the referee. Is it or is it not? You stated so yourself on record that your job is being the umpire.
Your Honor, can I ask, can Ms. Patterson please be excused?
Yes, you can be excused. My apologies.
My apologies too, but it needs to be some truth. Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm going to make a record about what
This
he's
is
referring
ridiculous,
to
man.
in count 77. Okay. The
And what
state-
happened to that paper? Because it was on the table. Then when I
Mr.
come
Brooks,
back in,
I
it's
need to
nowhere
make
to
a
be found.
record of a variety of
So who
things.
took my paper?
And you keep interrupting me repeatedly today. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly,
Okay,
sir.
whatever.
So you're doing it once again.
Whatever. Just make your record.
The document that Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count, and they have prosecutorial discretion, and I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's, I can't answer. It was dismissed because the request was made, sir. They don't need a reason. There's an abundance of case law about prosecutorial discretion. And they chose not to pursue that. My
Your Honor,
guess
Your Honor,
is maybe
with
to
all respect-
simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Opper, would you like to provide a basis for why the state sought dismissal of that charge prior to the start of this trial?
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to me, sir.
I tried, yeah, and I've been trying to find it ever since I came back in here, and now all of a sudden I can't
And now
find
you're impugning, though, like somehow you're impugning the integrity of this court,
No,
of the
I'm not.
bailiffs of this state. You're accusing, frankly, everyone
Did I
of
point
moving
the
your
finger?
papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did,
So
sir.
how can you make the assumption that I'm saying?
Can
that
I
I'm
please
pointing to
make the
someone?
record without
Yes,
you interrupting
yes, you may.
me?
Yes, you may. I apologize.
I appreciate that. Thank you. But you made repeated comments, sir, about I can't find my documents, I don't know what happened, things of that nature. When you came back out, you took multiple minutes before you even asked your first question of Ms. Patterson. And if I need to, I'll have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone touched my table? I didn't
You
say
implied it, sir.
But did I say that?
You
never
stated
said,
it implicitly.
I never asked the bailiffs, hey, did any one of you touch my table? I never said that to them. I just said, I can't find my paper, which is the truth.
And the way
looking
that
down.
you said it, like,
I didn't point anyone out, though.
And like,
I
well,
don't
that's
think that
kind
that's
of
fair.
interesting.
I don't
I don't
think that
have a
that's fair to
document that was
assume.
just on my table. That is what you said.
That's
Words
what
to
I
that
said, but I
effect.
did not point the finger at anyone.
So,
I
you
can see
have
if
the
I
letter.
came in, Your Honor, with
You've
all
been
respect,
given.
I can see if I came in and said, hey, one of you moved something off my table, or if I would have directed that towards the state, or if I would have directed that towards the clerks or something like that, then that would be more of a validity to what you're saying.
I need to continue with the record, sir. It's very apparent to me, sir, that every time, I can't say every time because that would be an absolute, but many times throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, or I want to make a record about some behavior of yours, or a further record about a ruling that you that was not in your favor, that you start peppering me with questions or comments, statements. You question me about the law. You ask, is it verified law? It is, from my perspective, a clear attempt to kind of turn us in a direction away from what we're doing, perhaps even to stall and to delay.
I'm sorry
That's
you
my
feel that way.
that I'm making a rule. You're doing it again.
I mean, because it has no validity.
So, I am trying to make a record outside the presence of the jury about a line of questioning you want to ask Ms. Patterson. Now, I've reviewed repeatedly up on the bench 90608 and 90616, which are two of the primary ways you can attack credibility. I've referenced one of those previously. 90608 is evidence of character and conduct of a witness. I'm not going to read through it all, but it's limited to character for truthfulness or untruthfulness. It's not specific instances of conduct. It's character evidence, which frankly wouldn't even come from the witness who's testifying. All right, then there's the statute on bias, 90616. All right, and none of the questions as I heard them went to a permissible topic under bias of witnesses. You generally said credibility. You did not give me any further explanation as to why you believed it was relevant to credibility. Now we have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs. I think, and you can clarify the record momentarily when I'm done, that you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether it has relevance to those issues. Number one, when did you receive this letter?
I received this multiple letters, actually, over a period of time. It wasn't, I referred to this one because this one had the pictures. But
and why do you believe it was from Ms. Patterson?
To answer your question with clarity.
Thank you. Does it have a date on it, the letter?
No, I didn't bring the letter, I brought the pictures. Because I thought, from my interpretation, I thought showing the pictures would be okay. How did I get these? So my mind was saying, show the pictures. They didn't come out of thin air. The witness knows that they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing, and oh, this and this and that. Oh,
I don't think she's ever said she was afraid.
Mm-hmm.
I think that was the officers who may have stated that, but I don't believe she ever said that. She specifically said today, when you asked her why did you, it was either why did you go back or why did you have, I'll look at my notes, and she said, I don't know.
It was why weren't you forthright with all the details? That was the question.
So again, I'm going to ask you, even if this letter's from her, these pictures are from her. How does it
Your
relate to
Honor.
her credibility before the jury?
Who else could these pictures be from?
I'm gonna ask you point blank, did you get a letter that's signed from her?
I got. What do you mean signed? No
How
one
do you
signs
know,
letters.
what's your why do you have a belief that they are from her?
I have multiple letters from her.
You're not answering my question. Why do you believe the letters are from Erica Patterson?
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was
Are
it the
you-
content
are you
of the
kidding me?
letter? No, I'm not kidding you. I need to make a record, sir. You're making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm gonna go out on a limb here.
And I'm asking you why you hold that opinion.
I'm gonna go out on a limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail. No one is gonna. When you
You're
say
not
to me,
answering my
when
question,
you say to
sir.
me,
What's
did-
the basis why you believe they're from Miss Patterson? Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying,
why
could
was
be anybody
somebody?
else.
This is.
You gotta answer my question. It's
Your
called an
Honor,
offer of
this-
proof.
But you still got to understand why this is mind-boggling to me. Like how I got a child with this woman. Why would I not know her handwriting?
But you have to
Why
lay
would
a
I not know?
foundation for these letters, sir. That might be
This
through
is
your own
ridiculous.
testimony. So that I'm trying to figure out why you believe they're from her. Not all this other stuff
Are
about
you
I'm in jail
serious?
and I have a child. I'm trying to I need to know. It's called an offer of proof.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious. I need you to
Because
answer.
they're from her.
But you're assuming
Like
that.
how else am I supposed to answer that?
I've given you a few reasons why it would lend to that opinion.
So it has to be put in a legal
The
term
bottom
or
line is I
something?
need the letter. So if you're gonna question her on that, the state absolutely has a right to see the letter. So you need to provide that letter. The bottom line is I'm not gonna allow any questioning without having that letter.
So
The
what
state
about-
has the ability to question you about that or question this witness and to look at the veracity of what your claims are here. So I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with
So-
you in court?
I just said no. How many
Okay.
times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
In
that
a
just
quiet
fine.
courtroom,
And everybody
yes, we can
assumes-
hear it very
and
clearly.
everybody assumes that it has to be disparaging. Or,
Once again, you're doing this tactic where
Because
you try to
it's not a
go
tactic,
off
it's
of what
facts.
we're talking
It's
about
facts.
to some other reason.
it's facts.
to
Because
some
I
other
find
thing.
it hard to believe that
I'm gonna
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm gonna let the
Come on,
state
man,
make a
stop.
record of why they
Stop.
believe it's objectionable because I haven't let them do that. I've given you multiple opportunities to tell me why you
So
believe
I
it's.
didn't get these pictures from nobody else. Why was
The
somebody
record will
else
reflect you have 2 pictures that you believe were from this witness.
that I know is from
No, that you believe.
that I know?
All right, I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
That's a lie. I object to
Let
that.
the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that that's what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that.
I'm not
because
done.
that's a lie.
Let him
Because at the
finish.
end of the day,
Let him
if we
finish,
gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she was when we met.
interrupting.
We can ask that question
He is
too. Then
over the
Did you
top
ask that?
animated
Do you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter
Dog
and he
gonna
can
sit
show
there and try
it
to
is
think he knows what's
inadmissible,
going
she will
on.
not be questioned. And under 906.11, I will
Then you gonna
declare
talk
the
about where my kids live.
cross-examination
You don't know where,
closed.
You don't know where, what
Thank
happened
you.
at the
We're in
time when
recess,
all this
1
happened,
hour.
bruh. Get your facts straight. So let's open the door on all of it then, so we can get.
All right, now at this point in time, we have come to a stopping point in the stream, where we will continue another time. Yes, and those that, as I said with the Brooks, we played that yesterday and a couple days before, and yeah, I was just going to help the cat with something, and then but I'm glad that the chat liked the Brooks videos, and we have some people that haven't seen some scenes of it, so. Dodgers, thank you for your commentary, Nan, and everyone else. Thanks for commentary and those lurking. I appreciate everybody. Yes. Hope the jury does the right thing. Yes. Right thing. Right. Yeah, Dodgers. He has all kinds of lines that can go a whole roasting book about. Definitely. Right. You liked the South Park when you saw that too? Okay. Yeah, I'm glad you enjoyed it, and I'm glad that y'all enjoy the streams. It really means a lot to me. All right, everybody, thank you all for tuning in and hanging out with me. We'll see you all on the next one, and peace. You're welcome, G, in chat. All right.